Okay, yeah, brilliant. Hi, welcome everyone. I have today the dual role of welcoming you, introducing the event, and then moderating the panel. So I'll take a few minutes before we move to the actual substance. First, welcome to the Bonavero Institute of Human Rights. My name is Maya Niezna. I'm a postdoctoral research fellow in modern slavery and human rights here at the Bonavero. And today's workshop is part of the Bonavero Institute's work strand on modern slavery and human rights as part of our membership in the Modern Slavery and Human Rights Policy and Evidence Center, or the Modern Slavery PAC. And human rights as they relate to modern slavery are one of the central cross-cutting themes in the Modern Slavery PAC's work. And for our own work strand, we understand the relationship between human rights and modern slavery to go beyond the protection and rehabilitation of victims, as a commitment to protect and promote human rights must inform policies and prevention efforts and respond to vulnerabilities before they become severe human rights violations. Our work on modern slavery and human rights emphasizes the link between the right not to be a victim of slavery, servitude, and forced labor, and other rights, especially the right to work and enjoyment of just and favorable conditions of work, as well as other human rights, such as the right to adequate standard of living and the right to access to justice. Today's event is our first for 2023 in this work strand. I think it's our first event of this year, and it reflects this understanding, looking beyond the extreme situation of modern slavery to consider also notions of decent work and consider responses to labor exploitation as they are reflected in labor law and public law, in policy and practice. We would hear today from brilliant experts from academia, law enforcement, and civil society. And I want to thank all of them for joining us. I also want to thank our fantastic events team for their support in organizing today's event, to Rosie Stewart, our events coordinator, and to Lara Ibrahim, the research assistant helping with today's event, and to the Modern Slavery PAC, especially to Owen Johnston for their help with today's event. Moving on to substance. Today's workshop will explore the meaning for legal standards, policy, and law enforcement of using different conceptual frameworks to address work and labor exploitation. The framework of modern slavery, as well as the broader term of labor exploitation, emphasize extreme forms of exploitation society aims to abolish. The framing of modern slavery, unlike that of labor exploitation, tends to also make a qualitative distinction between the most severe forms of exploitation that are or should be criminalized and what it sees as lesser violations of labor law, such as long working hours and wage that falls below the minimum wage. The framing of decent work, as used by the ILO and some NGOs, and we'll obviously hear about this soon, in some initiatives that we'll hear about, is linked with ideas for how work and perhaps society in general should look like. Decent work, as defined by the ILO, is aspirational. It refers, among other elements, to notions of employment opportunities, adequate earning, combining work with family and personal life, security of work, equal opportunities, safe work environment, and social dialogue. Choosing whether to focus on what we must abolish or on how we imagine decent work has different gains and losses for policy, legal standards, enforcement, and compliance, for example, by employers and businesses. Today's speakers will introduce some of these considerations and share valuable perspectives. We'll hear first from Deidre McCann, who will be joining us online. She's a professor of law at Durham Law School, researching labor law and policy at the domestic and international levels. Her work includes numerous books and articles and has a particular focus on the regulation of precarious work, working conditions, and the comparison of labor law regimes, as well as the influence of state norms in low income settings. Professor McCann is a fellow of the Academy of Social Science, a co-founder of the International Research Network on Regulating for Decent Work and a former official of the ILO. Since 2017, she had led a series of projects funded by UK Economic and Social Research Council and Global Challenges Research Fund on decent work regulations. And we'll start with her. She's ready? Ready?
Yes, thank you. Can you hear me okay?
Could you all hear? Okay. Yeah, we can hear you fine. Thanks.
Okay, thank you. I'm just sharing my screen. Is that fine?
Yes, thank you.
Okay, thank you. And thank you to Marion for this invitation. I was privileged to be on her Viva panel already over a year ago and to engage with the early work of already an important scholar and future leader. And it's my pleasure then to be invited to the workshop today and to play a role in relation to this new direction in Marion's work. And it's a particularly impressive effort, if you don't mind me saying, to bring together researchers and stakeholders into this very valuable dialogue. So my contribution this afternoon centres on the concept of decent work, discussing research that perhaps might be more global and conceptual than the primary focus of the workshop, but I hope of some use to the discussion. My work, I should say, doesn't focus essentially on modern slavery or forced labour or extreme forms of exploitation. It tends to focus on working conditions, but it has engaged with what Marion has characterised as a more positive framework of conceptualising and addressing exploitation, namely decent work. And so I'm suggesting that my work in this area could bring something to our thinking on labour exploitation in the way that decent work as a concept pitches the desired outcome, decent work, at the core of the conceptualisation of the problem. And as I'm taking this notion that's been proposed of positive and negative frameworks to imply. So I'm focusing on my previous research that has built on the decent work paradigm that conceptualised and proposed a regulatory model for what had been termed unacceptable forms of work, or UFW. And in line with the vision for this workshop, I'm going to make some suggestions on what we might see as the merits of a model oriented in this positive way. So most of us will be familiar with the notion of decent work, of course, an emblematic aspiration for working life, an enduring conception, widely valued, widely adopted across the years, occupying a considerable policy and discursive space. It's defined, as I'm sure familiar with, in the words of the ILO Director General's report to the International Labour Conference in 1999, where it's encased in an elaboration of the goal of the organisation, which is to, it says, promote opportunities for women and men to obtain decent and productive work in conditions of freedom, equity, security, human dignity. And that notion then, as I said, has been enduring. It's still very prominent in the ILO policy context. So, for example, it features throughout the ILO's guiding statement that marked its centenary in 2019, the Centenary Declaration, most prominently as part of Section 1B of the Declaration, in which there's an expression of the urgency of shaping the future of work towards a decent work objective. It was central in last year's resolution to expand the fundamental principles and rights of work by including a safe and healthy working environment, a very significant international achievement. And perhaps, of course, it's been most prominent in recent years among the UN Sustainable Development Goals. So I've singled out there goal number 8, which marries sustained, inclusive, sustainable economic growth, as it's termed, full and productive employment, and decent work for all. So in my work, I've drawn on the decent work framework as a starting point for a model for first identifying and then regulating working relationships that don't reach that standard, characterised by the ILO, at least at the point of this project, as unacceptable forms of work. And I thought it might be useful then today to return to that project from now a few years ago, but to reflect on it further with an eye to its pertinence to the themes of this present project. So the research I'm referring to was work that was carried out initially for the ILO in collaboration with Judy Fudge, and it was in the mid to late part of the last decade. I subsequently built on that project, on a series of projects funded by the Global Challenges Research Fund and ESRC, initially on legal regulation of UFW, including some work on the garment sector in Southern Africa. So again, there was a focus in this project beyond the UK. As I said, the project was on what's being characterised by the ILO at that point as unacceptable forms of work, a framework used broadly to capture working relationships perceived to be the most adrift from decent work. So you can see on the slide the definition of UFW from the ILO policy documentation as work in conditions that deny the fundamental principles and rights, risk lives, health, freedom, human dignity and security, or keep households in conditions of extreme poverty. UFW was at that point identified as an area of critical importance for the ILO, but without a comprehensive elaboration of the concept or its dimensions or manifestations. And the ILO called for a more refined understanding of UFW. This research project, which started from there, was a contribution, at least in part, to that discussion. So I'm suggesting then, again, it may be worth returning to that work for its insights into potential frameworks on exploitation for the discussion today and perhaps subsequent work. The aim at the time was to develop a framework for understanding and addressing UFW, and we wanted to recognise that certain groups are profoundly adrift from decent work, and that the task of improving working life is subject to a degree of complexity. To that end, we reviewed what we saw as the key discourses in contemporary working life to identify what contributions they could make to a robust conception of unacceptable forms of work, for example, on precariousness, informality, forced labour, vulnerability. And we proposed a new multi-dimensional model of unacceptable forms of work to identify and target them, and potentially to be used or available to be used in countries at a range of income levels. So again, it was intended as a global model. So to offer this model as a consideration for today and part of our exploration of framings of labour exploitation, I want to make a few suggestions about it. And these relate to the project of exploring the potential strengths of framing the problem of exploitation as an aspiration to decent work. So we broadly defined unacceptable work as jobs that must most urgently be improved or eliminated. We wanted the model to be available as a diagnostic tool used by actors, local policy actors. We envisaged researchers, governments, social partners, civil society organisations to construct their own models of unacceptable work suited to the local context at various levels, with the aim of, first of all, identifying UFW and then deciding what to do with it. So the intention then was to be pertinent to a range of economies, different levels of development, and suited to regional, national, sectoral or occupational contexts. We wanted to identify substantive features or a set of risks to allow policy actors to be sensitive to local political, economic, social contexts, to take into account the magnitude of any particular risk in that local setting, and patterns such as the concentration of certain forms of exploitation or unacceptability among certain groups of workers or certain sectors. And we wanted to focus on sites with the potential for effective regulatory intervention and effective regulatory strategies, with a preference ultimately for strategic regulatory strategies. So it's interesting then or it has been interesting for me to return to that model and consider how it can contribute to the puzzle that Marion has presented for this workshop, how we approach labour exploitation, especially from this positive orientation, as we might call it, focusing on decent work, and how it drives this model, and whether I would suggest it might have broader resonance for our discussion. So first, if I can speak to the substantive dimensions of the model of unacceptable forms of work, particularly noting that the decent work framing permitted it to encompass, but to be broader than, features that we would think of, or treatment that we would think of as forced labour or modern slavery, to give an expansive model of what we might consider unacceptable. And the way we did that was to identify a set of dimensions of working life in which unacceptability can emerge. And we came up with 12 in total, you can see on the slide. So some of these are fairly conventional. They're common in typologies of good work or job quality, for example, working hours, income, health and safety. Others are more novel in those kinds of typologies, in particular, those that are not job-centred. And we included in that regard the nexus of work and community life, social protection, the collective aspect, work organisation, which is not always present, and perhaps most notably novel, legal protection. So first of all, I suppose I'm suggesting most obviously that by adopting this more positive orientation, there's a capacity to provide a more expansive and perhaps more sophisticated models of unacceptability in a conception of unacceptability or exploitation. So I would say it gives an appropriately complex and capacious picture of working life. And including in that regard dimensions that are sufficiently expansive and flexible to catch novel risks to decent work as they emerge. So in a piece that's just come out in the Journal of Law and Society, I reflect upon what I refer to as the labour regulatory dimension of deification of work, including by revisiting the UFW model in that context to reflect on the evolving and transforming risks of unacceptability in these dimensions. Because obviously working life has evolved dramatically since the original project. So I point there, for example, to increased datification as increased data intensity, as an increased technological capacity for surveillance, tracking and documenting worker activity, which can be classified both within the equality, human rights and dignity dimension of this model and the work organisation model. There are new forms of inspection and management. They potentially erode the space for workers to exercise autonomy and professional judgment. As we know from the research, that can be categorised under work organisation. The nexus of working time and wages is crucial in datafied work. Increased data intensity makes available more intricate tools of time measurement and governance, and that can be associated with the nexus of the working time and income dimensions of the model. So that would be the substantive dimensions of this model and their significance to the present discussion. The second element I would highlight is that a positive model allows us to conceive of a continuum of working relationships, and that stretches in this model from unacceptable forms of work to decent work. So some jobs are obviously clearly unacceptable, modern slavery inevitably among them. Others constitute decent work or good jobs. Others harbour elements of unacceptability but don't reach the full standard of decent work. So this continuum notion then, of course, is going to be familiar in your work from the literature on forced labour and models that have evolved within that literature to conceptualise forced labour as a continuum. Within this particular continuum model, the multi-dimensional model, an intermediate category of jobs is recognised, and the model endeavours to point to a route through that intermediate zone, and that's because it's indicator based, as you can see on this slide just as an illustration. So under each dimension, of unacceptability, we identify a set of indicators and then classify those indicators, some designated as fundamental, some supplementary. You can see on the slide one of the dimensions 5 of working time, and there the fundamental indicators are in red and starred. Supplementary indicators are the others. So the fundamental indicators identify globally applicable worst forms of work, entirely unacceptable, and indicate a core of basic universal rights. So, for example, coercion, risk to safety, health, well-being, expected, etc. And we expect these to feature in all typologies of unacceptable work. Supplementary indicators really highlight the contingent nature of unacceptability and its variation across different settings. They're context specific, they're linked to levels of development. So I've included in the slide, for example, an illustration of working time. You can see that the fundamental indicators are excessive weekly hours, insufficient weekly rest, forced overtime, etc. The others are not considered as urgent, but still important, unpredictable schedules, lack of influence. So in that approach, given the continuum model, we hope to develop a model sensitive to socioeconomic cultural context. We assumed that manifestations of unacceptable work vary from country to country, and the continuum model indicates the need to improve on a range of dimensions and allows dynamic choices and priorities. So this design as a continuum also makes it a dynamic model. There's a sense of direction seeded in this model, isn't there, towards decent work. And in our model, the fundamental and supplementary indicators present a path that's envisaged for policy actors to take incremental steps towards a phased elimination of unacceptable work. So it's about a sequencing of interventions. And my final point about the merits of a positive model, and I suppose this is because the sense of the model as dynamic made me reflect upon what insights could be garnered from returning to this model, to the debates on unacceptable work, and picking up on that enduring aspiration for decent work in this year, in the present context in 2023. So one point I would make to finish is to note that when this model was being developed in the middle years of the last decade, it was prior really to the more intense concern about a rapid escalation of casualisation in at least certain jobs or sectors, whether associated with platform work, with a broader deification of work, or through just intensified forms of conventional casualisation pressures. But it prompted me to sort of rethink the continuum dimension of the model in the current context in 2023, and the direction or flow of that continuum, and what I would suggest for policymakers, which is to say that the downwards path of the continuum would be more of a concern in many national settings than it was at the time when this model was developed, at least in the global north. So I've been framing, I suppose, the continuum as positive, as a path to decent jobs, but flipping it, and unfortunately you could always also see it as indicating a path to unacceptable work. It points to the argument that casualisation or informalisation should be an element in, and in some settings a more prominent perhaps element of the debate on labour exploitation. And clearly I'm not the only one to make that point. In my work, it goes back to a chapter I published in Diamond Ashi Agbor's volume on informal work in 2019 on informalisation as an element of notions of the transition between the informality and formality. And I characterised the phenomenon as an unravelling to highlight the presence of informalisation in that context, in the sense of an unravelling of once decent jobs and their regulatory supports. So in a global context, at that time, I was arguing that informalisation should be more prominent in the transition paradigm. In debates, often with a focus in the global south, my argument at the time was about paying attention to the presence of informalisation in the ILO instrument, recommendation number 204. And we proposed a regulatory dimension to the UFW model. Just to finish it, you can just to finish, sorry, you can see that in a 2019 paper that we published in the Journal of Law and Society. In our initial work, we did look at the regulation of zero hours contracts in the UK, illustrating really the failure of a regulatory measure to address a range of dimensions that make forms of work unacceptable and ensure effective enforcement. But I guess I would end by suggesting that in our present era, we might need even more attentiveness to regulatory strategies that act as a barrier to the disintegration of decent jobs into unacceptable or exploitative forms. And certainly I've reflected on those issues, and particularly as they relate to working time. Jill Murray and I have made some suggestions. I come back to that in the context of the Supreme Court judgment in MENCAP. And we may need, I suppose I would suggest, to sustain the very discourse of decent work and other positive models as they come under great pressure. And that might be in relation to broad expectations about the nature of working life, including for many here in the UK, and perhaps even a decline in support for the mechanisms that sustain decent work, which I might suggest we're seeing around us as we speak. So I guess I'll end on that thought. I hope these thoughts were useful, and I'm very much looking forward to hearing from others. Thank you.
Thank you so much. This was fascinating. Our next speaker is Professor Anne Davis. She's a professor of law and public policy and a fellow of Rathmell's College here at Oxford. She's the author of 5 books and numerous articles in the field of public law and labor law. And among her roles, she chairs the Procurement of Government Outcomes Network for the Blavatnik School of Government at Oxford, and is a non-executive member of the Board of Parliamentary and Health Services Ombudsman. She previously served as an independent member of the Council of the Advisory, Conciliation and Arbitration Service. Professor Davis is currently working on a project on remedies in employment law that I expect will also inform some of her remarks today. So
thank you very much. Thank you. It's lovely to be here. I'm, as that will have just made clear, not an expert on modern slavery at all. I'm a generalist employment lawyer, and my interest at the moment is around enforcement and remedy. So that's the perspective I'm going to bring to bear on this problem of labour exploitation. The focus of my comments is going to be on the UK. And it's going to be sort of more conceptual. So hopefully when we get on to the second panel, we'll hear a bit more about practicalities of enforcement. That's not my area of expertise. I'll be thinking a bit more conceptually. So I was going to start by defining decent work, but Deirdre's done such a fantastic job of that I feel I can't better it really. So I'm happy to kind of adopt with massive thank you what she's just talked about in terms of defining decent work. And I think when we're thinking about that continuum in relation to the UK, as a country with a very high level of development, you would expect the UK to be at the end of the spectrum where there is a heavy emphasis on securing decent work for everybody in the labour market. There really are no excuses not to be pursuing that agenda. So I wanted to think a bit about, I guess, the question that begins this panel. What does it mean to say that the problem of labour exploitation is framed as a problem of modern slavery rather than as a problem of decent work? And if we think about the law in the UK and we look at the substantive law, decent work standards are there. They are upheld. So enslaving someone is a criminal offence with serious penalties. Deliberate non-payment of the national minimum wage is a crime. Other kinds of non-compliance with the national minimum wage are civil wrongs and arrears can be recovered. Freedom of association is protected by statutory rights not to be discriminated against for trade union membership and activities. There are elaborate health and safety duties on employers backed up by criminal sanctions. Injuries to working people are actionable in contract and tort. Workers can bring tribunal claims if they're denied their paid holidays. Discrimination is unlawful under the Equality Act 2010. Now, I know that every Labour employment lawyer in the audience is going to have been rattling off in their mind a list of all the things that are wrong with those bits of legislation, all the ways in which they're inadequate and could be better. But that's not really what I'm concerned with today. Of course, there are ways in which those substantive standards fall short, but they are there. Decent work is there in the substantive law. So what's the basis for saying that labour exploitation is not being framed as an issue of decent work? Well, I think one way of answering that question, and perhaps we'll come up with some others later on, is to do with enforcement. So let's think about how we enforce employment law. Let's step back from modern slavery for a second and just think about the enforcement of employment law in general terms. So the enforcement of employment law is typically seen as a private matter for the affected individual to enforce through litigation. Of course, we have a tribunal system for this, and that's the principal place to go rather than the courts. And that was created with a view to making the system more accessible. But there are some very well documented problems, even with the tribunal system. So there are lots of sources of advice, trade unions, citizens' advice, other NGOs, they're all doing their best. But without easy, free access to expert advice, many people don't realise that something that's happened to them at work that didn't feel right is actually unlawful and forms the basis for a potential claim in the tribunal. There's a great piece in the Industrial Law Journal by Nicole Busby and Morag McDermott that goes through some of those issues, and they've published elsewhere too on that, and it really brings out that problem. People who do bring a claim in the tribunal system often give up, or they settle for less than they were probably entitled to because the process is stressful and difficult. They don't get all the way to the end. A majority of employers have legal advice when they actually appear before a tribunal, and we know from classic research by Hazel Genn and others that that gives a significant advantage in terms of winning the case. So the system of private enforcement is broken. I think we can't put it in any other way. Let's think about that in relation to a worker who's been working under conditions of extreme exploitation. Maybe someone who's been injured after being forced to work in dangerous conditions, discriminated against, not paid, and so on. So all those problems that I've just mentioned apply to that person, but they may find it even more difficult to bring a claim in that kind of setting or to access advice. They may have reason to fear the authorities. They may have been led to believe that the authorities will have it in for them. They may be anxious about being deported if they're not a UK national. There may be language barriers. And of course, there are enormously long waits for tribunal hearings. It takes about 2 years to get a claim before a tribunal at the moment. If you're only in the UK on a temporary basis, that isn't much good to you. And the other problem, of course, is a more technical legal problem. So although the courts have developed a more sympathetic approach to illegality issues in cases like Hunga and Okadina, this doctrine can still act as a barrier to private law claims. So you bring a claim, but the court says, no, you're precluded from bringing that claim because you were not working legally in the first place. And the impact of the illegal working offence in the Immigration Act 2016 is still very unclear in this space. So this is an area of legal risk and uncertainty for people. Now, of course, employment law can also be enforced by public agencies in certain circumstances, and I've already mentioned some examples of that. So there are some criminal offences, and part of the point of criminalising an employment-related wrong is to harness the condemnation of the state, and that takes us into the space of public enforcement. So, of course, we have the slavery and trafficking offences, acting as a gangmaster without a licence, deliberate non-payment of the minimum wage, non-compliance with health and safety duties and working time. And we do have other public enforcement outside the sphere of the criminal law. So the licensing system for gangmasters, and HMRC's role in recovering minimum wage arrears for workers. Now, public enforcement does overcome some of the problems with private enforcement. Workers might need to contact the relevant agency to tell them about their problem, but they don't need to formulate it in legal terms. They don't need to frame and bring a case. And criminal offences do involve strong public condemnation of bad employers and may have a deterrent effect, though obviously that's a contested issue. But the effectiveness of public enforcement inevitably depends on how well enforcement agencies are resourced. If you look at the latest report from the Independent Anti-Slavery Commissioner, modern slavery prosecution levels are very low relative to the estimated prevalence of the problem. And there is a real tendency, I think, on a political level to assume that if you criminalize something, you fixed it. That's the problem solved. And that leads to a neglect, I think, of redress for affected workers. There are well-documented problems around support for survivors of modern slavery. And although the Gangmasters and Labour Abuse Authority does really well at securing redress for affected workers, it doesn't do that on the basis of formal powers. It does it by informal means. So thinking back to our worker in a situation of serious labour exploitation, contacting the authorities is still a thing here, and it's still difficult for all the reasons I gave earlier. Once you've done that, the authorities may not take action. For example, there may not be enough evidence to prosecute. The person may have to give evidence themselves and may endanger themselves or their families in doing that. Deportation is still a serious threat for non-UK nationals, and they may not end up with any redress from the employer at the end of the public enforcement process. So, upshot, sorry, I've cast a gloom, haven't I? The law does require decent working conditions. Labour exploitation is framed as a problem of decent work, but it just doesn't provide the mechanisms for enforcement. There's marginally more chance, I suppose, of a prosecution for a modern slavery offence than there is for people to bring litigation. So in that sense, maybe the framing is more about modern slavery than it is about decent work. But ultimately, enforcement, I think, is the real challenge here. So just to conclude on a slightly more positive note, what would make it better? Well, a well-resourced labour inspectorate would make it better, with a range of powers across decent work rights, so with criminal and civil penalties against employers and the ability to secure redress on behalf of workers. Better support for litigants where private enforcement remains the main method of enforcement, and greater trade union presence in workplaces, because one of the things that people don't always notice about the decline in trade union membership and presence is that trade unions have a really significant role to play in preventing disputes from ever reaching the stage at which anyone needs to litigate, in providing grievance processes, providing dialogue to stop those problems crystallizing into dispute. Now, I appreciate that these things are not terribly likely to happen, but what they do is show the extent of the problem. This is what we need to fix it. So it's a pretty serious problem. And ultimately, for many people, a decent experience at work is more a matter of luck than anything else. They end up working for a sensible employer who's happy to do the right thing because they know it's the right thing, without the need for legal threats to motivate them to do that. And where that isn't the case, the law is really unjust. It purports to lay down standards of decent work, but makes them very difficult to enforce. And that's what many people would term a structural injustice. So nobody means it to be unjust, but that's the way it turns out. So I'll stop there and look forward to discussion and questions later. Thank you.
Thanks so much, Anne, and thanks for trying to make a discussion about modern slavery slightly less depressing than it might have been. Our last speaker for this panel is Elena Pai, and she's reading for a DPhil in law, also here at the University of Oxford. She specializes in the use of public procurement to address modern slavery, which is going to be the topic of comments. And in UK government supply chain, Anna tutors employment law at Oxford and was previously the coordinator of the Oxford Business and Human Rights Network. She holds a Master's of Philosophy and a Bachelor of Civil Law from the University of Oxford and a Bachelor of Laws from Queensland University of Technology. Before coming here, she worked as a solicitor in Brisbane, Australia, practicing in commercial litigation and arbitration, and she will also be moderating the next roundtable. So you're going to see her again soon. Thank you, Ella.
Thank you, Marianne, and thank you for the opportunity to speak on this panel. So today we'll be talking about modern slavery in the context of UK government procurement. So the government spends enormous sums on procurement every year, and many modern slavery advocates, both in and outside of government, see this buying power as a really important tool for changing corporate behaviour. Government is also starting to face potential legal liability for not undertaking due diligence for modern slavery risks. So what this means is that the issue of modern slavery is now squarely on the government's agenda, particularly in public procurement and in its social value policies. So today I'll be talking about how the UK government constructs the problem of modern slavery in its public procurement. My focus will be on the assessment of modern slavery risks by government departments. I will briefly discuss the process of risk assessment in public procurement and then highlight two key limitations with the current approach. So in UK public procurement, the problem of labour exploitation in markets is framed through the language of modern slavery and the Modern Slavery Act. When purchasing from external suppliers, departments are concerned about what they describe as rooting out bad suppliers from their supply chains. And they're particularly concerned with ensuring that taxpayer money is not spent on criminal activity. In other words, they seek to eliminate the kind of criminal suppliers or the bad apples from their supply chain. And this approach is facilitated by current procurement regulations and the soon-to-be-passed procurement bill, which focus their modern slavery efforts on contractor exclusions. Unfortunately, the concept of decent work is not really part of the UK government and the department's modern slavery vocabulary, nor does it really play any role in the statutory framework for public procurement. However, my focus today is not really on the merits of a modern slavery or a decent work approach, so to speak. Rather, my focus is on how public procurement risk assessment frameworks shape how UK government departments think about and construct the problem of modern slavery. These risk frameworks are primarily located in the internal administrative law of the UK government. To understand the legal and institutional context in which modern slavery risk assessments take place, we can look to the policies, procedures, and practices published and adopted by government departments. Helpfully, these are summarized in many of departments' modern slavery statements, which were recently published, mostly towards the end of 2021, which I have reviewed as part of my research. When reading these modern slavery statements, it becomes clear that departments think about modern slavery in terms of risk. When they talk about tackling modern slavery in public supply chains, what they're really talking about is reducing the risk that the money they will spend will fall into the hands of a supplier who acts illegally in exploiting workers. How modern slavery is constructed as a risk then shapes how it is assessed and managed. The bad apple idea is central to the construction of modern slavery as a risk in public supply chains. I will come back to this idea later, but first I'll briefly outline the general process for assessing modern slavery risk in public procurement. So as a first step, either pre or post-award, departments undertake a so-called light touch desk-based risk assessment of their new or existing contracts, determining risk based on several factors, including industry, commodity, location and context, as well as business model. The purpose of this initial light touch risk assessment is to determine which, if any, suppliers need to complete the Cabinet Office's Modern Slavery Assessment Tool, which is also referred to as the MSAT. Many departments reported on the results of these initial assessments in their modern slavery statements. Some said they had a few high-risk contracts, although most found the majority, if not all of their contracts were low risk, typically because their first-tier suppliers were based in the UK, US, Australia, Ireland, and mainland Europe. Even the Department of Health and Social Care concluded that most of its business-as-usual non-COVID contracts were low risk. Some departments acknowledged that they need to look a bit further than their first-tier suppliers, although in general supply chain mapping is not undertaken particularly widely. Nevertheless, all departments reported in their modern slavery statements that they had asked at least a portion of their suppliers to complete the MSAT. The MSAT is a self-assessment tool, which includes around 30 questions about the usual topics, including organizational structure, modern slavery incidents, steps taken to address modern slavery, etc. In fact, it broadly reflects the questions and information that a corporation might put in its modern slavery statement under Section 4 of the Modern Slavery Act. Once the firm has completed the MSAT, the tool then scores the supplier responses based on a red, orange, yellow, green performance scorecard and rating in 6 areas, including governance, policies and procedures, risk assessment and management, due diligence, training, and KPIs. The MSAT also provides the supplier an overall score of red to green and standardized recommendations for improvement. Across all the modern slavery statements, none of the MSATs revealed any incidents of modern slavery. And in general, most suppliers scored highly, thus putting them in the green category or sometimes the yellow category. Those scores were generally attributed to limitations in governance and training arrangements. So it's not difficult to identify the ways in which the UK government could potentially be doing more to address modern slavery in their supply chains and to improve their modern slavery statements. However, my aim today is not really to compare these statements to best practice. Instead, I'm focused on what these risk assessments what these processes tell us about how government constructs modern slavery in public procurement. And on this, I have 2 points. The first is that the modern slavery risk assessment frameworks in public procurement embody a relatively thin account of modern slavery. So we know that modern slavery and labor exploitation is a highly complex problem, which can be constructed in a range of ways. And the modern slavery decent work distinction is a good example of this. So when dealing with complex problems in public administration, such as modern slavery, risk frameworks require political, normative, and practical choices to be made. In public procurement, the modern slavery risks, which I emphasized, are those that align with government priorities and that are thought to be capable of management by procurement officers, while minimizing burdens on both purchasers and suppliers. These risks are also constructed through the process of translating them into workable tools of risk management. The result is a framework which translates a particular conception of the problem of modern slavery into a set of risk management tools, indicators, and solutions which are accessible to procurement officers and can be completed largely through desk search. At this point, what is evident from a review of the department's modern slavery statements is that we are left with a thin account of modern slavery, one that simplifies a very complex problem and frames it in a way that is capable of being solved by identifying and dealing with the unscrupulous suppliers in public supply chains. The MSAT, for example, while certainly very useful in highlighting some common risk factors for modern slavery, is ultimately a self-assessment. So MSAT questions are read and interpreted by suppliers within their own existing frame of reference, and thus possibly may not reveal any new information not already in the supplier's modern slavery statement. The standard questions do not really engage with the structural and socioeconomic complexities that contribute to the problem of modern slavery. So what this means is that where the company has the right policies in place, the risk of modern slavery may be determined to be low, as was the case in most departments' modern slavery statements, even if that does not actually reflect the situation on the ground. The ongoing challenge in public procurement is that public procurement officers with limited time and resources and sometimes limited training on modern slavery are being asked to identify risk, assess supply of modern slavery statements, and make decisions with potentially significant consequences based on relatively little information. So it's important that departments remain wary of the limitations of current approaches to constructing modern slavery and continue to look for ways to adopt a more expansive interpretation of the problem, which is something that the other two speakers on this panel have touched on today. My second point is that in public procurement, modern slavery risk frameworks, there is a strong emphasis on procedure over substance. So in relation to the so-called audit explosion in UK public administration, Michael Power observed that a problem with audit is that it tends to shape the environment being assessed, as that environment becomes increasingly structured around measures which are replicable, consistent, and capable of monitoring. The modern slavery statements of government departments indicate that something similar might be happening with the risk frameworks for modern slavery in public procurement. The process of risk assessment is shaping how government departments think about modern slavery, and the risks are increasingly conceived through indicators that can be quantified, identified, or measured, such as location, industry, and commodity. To mitigate the risks of modern slavery, key performance indicators are then manufactured by the risk assessment process. They are made simple enough that they can be reviewed frequently and give the appearance of transparency and control. For example, common KPIs outlined in the Departmental Modern Slavery statements were to train more staff, invite more suppliers, to complete the MSAT, and to request more supply chain maps. These KPIs are also framed in a way that ensures they're capable of managing liability that a department may face if modern slavery occurs in the supply chain. So from this, we may observe that the mitigation of modern slavery risks is in turn becoming increasingly self-referential. Improvements may start to be defined in relation to a sort of system loop, rather than in relation to the original policy outcome. In other words, it is measured by the verification of policies and procedures rather than by substantive and policy outcomes, such as the protection and support of workers and their rights in public supply chains. So I'm not suggesting that procedural actions are not valuable. In fact, they are incredibly important for driving action, and they do certainly on quite a significant level contribute towards substantive outcomes. But what I am suggesting is that the emphasis on procedure in modern slavery risk assessments is potentially limiting the kinds of risks and risk management strategies that departments are identifying and acting on. It is important to be aware of these limitations so as to avoid viewing modern slavery risk with blinkers on. So to conclude, there is certainly work to be done to improve these modern slavery risk assessments and the frameworks to ensure they are actively working towards the protection of workers in public supply chain. However, I think it is important to acknowledge that they are already playing a very important role in embedding modern slavery as an issue in the day-to-day culture of public administration and public procurement. And it is clear from modern slavery statements that departments are genuinely interested in taking action in this area. It's simply that remaining wary of potential limitations is important as departments work towards using their buying power as a force for change in public supply chain.
Thank you very much. So these were really interesting papers, and I'm going to open the floor for questions, first from people in the room, and later we'll see the questions we have in the chat. I'm not going to take too much time for my own questions. We might get to this later. I think it's interesting to identify some common themes in what we already heard. So some of the things that come to mind are there is emphasis on the use of diagnostic tools as part of the unacceptable forms of work framework, and the notion of an indicator-based approach that is linked in an interesting way to this notion of risk assessment and thin accounts, and to what extent perhaps we could look at these thin accounts as a way to narrow down complex problems, and whether something like unacceptable form of work or decent work could help us get to the next stage, or might it again be used to narrow this account. So I think this could be one interesting question to look at, the question of positive framework that allows us to look at the entire continuum, whether this is something that could work in the same environment, regulatory environment and enforcement environment, as we currently see definitely in the case of the UK. Also the case of the limitation of the system as they currently work for definitely private enforcement in practice, and some of the limitations we see for public enforcement, at least on how it actually works. And I think there's also the interesting theme of condemnation, and to what extent the notion of condemnation and the label of modern slavery or label of labor exploitation, what kind of work does this do? And can we imagine effective work with something that might not carry this weight, with something that is framed a bit more positively? So I think this could be another interesting question. And obviously the point of structural injustice that I think we see in different levels of all the papers we heard in this panel. I don't know whether any of you want to briefly comment on something that we heard from the other speakers, or whether you prefer to start with questions. So questions, Idri? Okay, I think questions it is. So let's start with people in the room.
Good afternoon, everyone, and welcome to the second panel of this event, Between Modern Slavery and Decent Work, Responses to Labour Exploitation. So I'm joined by a really impressive group of speakers, both in person and online today, who work in policy and practice in this area. I only unfortunately have time to make the briefest of introductions, but I would encourage everyone to look these guys up on social media, or to have a chat to them afterwards if they have time, because they all have really interesting projects going on and have really interesting backgrounds as well. So there's much more to learn about them than unfortunately I can tell you today. But just to make a start, we have Neil Wilkins, who is head of Migrant Workers Program at the Institute for Human Rights and Business. Neil has also worked extensively with the construction, apparel and hospitality sectors, both in the UK and abroad, including the Gulf and Southeast Asia. Frank Hansen is head of prevention and partnerships at the Gang Masters and Labour Abuse Authority. Frank has been instrumental in developing a Level 1 award in worker rights and labour exploitation, which is a unique qualification to help individuals and communities understand their workplace rights and to protect themselves from labour exploitation. Kate Roberts is head of policy at Focus on Labour Exploitation. Kate has a background in workers' rights, campaigning and advocacy, as well as anti-trafficking work, and has previously worked for Anti-Slavery International and Kalayan, and headed the Human Trafficking Foundation. Yeah, I looked up. I wasn't intending to look specifically at you, but now I'm looking at you. Ake Archie is a former child labourer from the Ivory Coast. Ake is starting to become a qualified labour migration law solicitor. He currently sits on the executive committee of the Human Rights Lawyers Association and started the litigant in-person services to support unrepresented migrant workers. And Peter McAllister is executive director of the Ethical Trading Initiative, a leading alliance of companies, trade unions and NGOs that promotes respect for workers' rights around the globe. Since joining ETI in 2010, Peter has led the development of a demanding new strategy that seeks to transform the way business approaches workers' rights, demonstrating impact for workers and value for business. So I think we'll start with Neil Wilkins. Neil, can you able to join us?
I am able to join you, but I'm unable to start my video because the host has stopped it. I don't know if you need to see me or not. I'm quite happy to continue without. So I'm Neil Wilkins. I'm head of the Migrant Workers Program for the Institute for Human Rights and Business. Anyone who doesn't know us, we're a business-focused NGO. We work closely with business to try to promote human rights in business operations. I'm focused very much on migrant workers, obviously. Just to give you some facts, there's 169 million migrant workers in the world, meaning that 1 in every 20 of all workers are a migrant worker. Migrant workers face many additional challenges and are more likely to be subject to exploitation, including modern slavery, than many others. Just to go back to the discussion before the break about company transparency, one of the things that we work on a lot is around the issue of recruitment fees for workers, for migrant workers, many of whom will be paying large recruitment fees to secure employment abroad. It's a situation where companies will talk about recruitment fees, so if they find that workers have paid recruitment fees, but usually only if they have a program in place to then deal with that. And I think that that would be true across a lot of issues where companies are criticized about transparency and admitting when they discover things. Companies will talk about things generally when they have a program in place to deal with it, but not unless. But migrant workers are a good illustrative example of what I think is a sort of core of the discussion today, and that's about the undervaluing of low wage and manual work and the sort of normalizing of exploitation that can go with that. And in this sort of new work paradigm discussed by Deirdre earlier, what we see in all sectors and all locations is the sort of removal of any human element in employment arrangements. The sort of very notion of decent, fulfilling work is actually challenged, and work undertaken and the workforce who undertake it kind of become units of production on a balance sheet. And as the totals at the top of that account are squeezed, so are the inputs at the top, with those inputs being increasingly divorced from the jobs or the tasks within jobs that they represent. And so to give you some examples, we see situations like hotel cleaners who previously would clean 4 hotel rooms an hour, now expected to do 6, or staff at an Amazon warehouse, a workplace so happy that even the boxes have a smile, having to hit stretch targets, increasingly stretched to the point of break-in. In many cases as well, we see the total removal of any employment relationship whatsoever, and staffing arrangements being outsourced onto agencies. And in this way, an employment contract between a business and its workforce is replaced by a business contract between 2 companies. And this allows companies, of course, to distance themselves from their workforce, and with it, an employer's responsibilities and commitments. And in outsourcing, some people might say shirking this responsibility, a door is left open to ever more exploitative terms and conditions for workers who face demanding work schedules, low wages, unrealistic piecework rates, and constant issues around overtime, holiday and sick pay. Also, informality and precarity of employment with few opportunities for training or advancement. These things being the very opposite of decent work that we'd all like to see. And these practices are now so ubiquitous that they've become the new normal. So much so that they fail to garner much excitement. We don't consider this to be modern slavery or related to it in any way. I was in Qatar last year as a human rights volunteer for the World Cup. And you'll remember that as part of the lather of excitement the press whipped themselves into during the last month before the tournament, a time when even the Daily Mail was seeking to position itself as a workers' champion, all of the talk focused on the most extreme examples of exploitation, mostly to do with deaths on construction sites. Now, there's no doubt that we perhaps have seen some welcome changes in Qatar, and time will tell if Qatar will make those changes permanent and make them last. However, the question I would like to put at the start of this discussion is this: was that interest and pressure for change because it concerned only things at the extreme end of the spectrum? Did you, for instance, ever hear once or see any newspaper or TV commentator talking about the thousands of mostly female migrant hotel workers in Qatar facing recruitment fees, persistent wage theft, sexual harassment, lack of grievance mechanisms, and other labour rights abuses. We've talked during the discussion already about labour exploitation being a continuum that moves from decent work through a range of degrees of abuse to the most egregious forms of modern slavery. However, of course, so much of the focus is at this extreme end. And that's our dilemma. Where is the newspaper headline about an outsourced hotel cleaning operation, or the security guards at a dairy plant, or the pack staff at a warehouse? It is perhaps the everyday, even mundanity, and then being the nature of decent work and its opposite, that we need to form part of our discussion today. Finally, I'd just like to make 3 further points just relating to framing. And again, I'll use the hotel industry perhaps as an example. When we talk to hotel companies about modern slavery, they immediately will start telling us about all the great work that they've done to prevent trafficking for sexual exploitation in their hotels. They will tell us about the training that their staff have undergone, the fact that they've got leaflets and posters up everywhere. And all of this is great. It's very credible and to the credit of those hotels, and doubtless does have an effect on preventing that form of sexual exploitation going on in those hotels. But that form of exploitation is external to the hotel and it's criminal. When we then ask the hotel about that's absolutely great, I'm really glad that you've signed the ECPAT code and you're doing all of those things. How do you recruit your cleaners? How is the due diligence that you undertake on the way that your kitchen staff recruited? How do you undertake that? What is the employment situation of your security staff? And it's when you start looking at those internal processes that the hotels perhaps haven't got such a good story to tell. So they're far happier talking about these external threats, these awful criminal gangs using their lovely hotel for nefarious purpose, rather than talking about their internal processes that might allow or even encourage, because that's the only way that you will get a contract, exploitative employment relations. The second point is around government and government regulation favouring criminal prosecutions rather than, again, the mundanity of labour inspection. And we're currently seeing things like the Gangmaster and Labour Abuse Authority, and Frank will have things to say about this, I'm sure, but suffering death by 1,000 cuts. And what we shouldn't forget about government regulation is that it doesn't just protect workers, it protects law-abiding businesses in this space. And you know, the Gangmaster and Labour Abuse Authority came about in part because of demand from business itself, that if business was going to do the right thing, they didn't want to be undercut by others who weren't playing by the rules. So we should never forget that government regulation protects law-abiding business, not just workers as well. Finally, I think that NGOs have been responsible for some of the promotion of modern slavery, because it's an easier way to attract funding than to talk about the things that very often we want to do work around. So if I go to a funder and say, I want you to fund us for a project on modern slavery, I'm far more likely to be successful doing it that way than saying, I want you to fund us for a program promoting decent work and labour rights. And yet the two actually are the same thing. So hopefully that's some useful questions perhaps to start the discussion.
Thank you so much, Neil. That was really fascinating. Sorry, Mayan.
The video should be working now, so Neil and Kate, we should be able to see them if they don't.
Okay.
I'll just give you a quick wave then.
Hi, Neil. Okay, now that the video is working, shall I pass the microphone on to Kate then? Perhaps Kate, are you there? Great. Hi.
Hi. Shall I present and then we have questions at the end? Yeah. Okay. I actually have some slides to share, so I will just share my screen. Give me a minute. Yeah. So briefly first, if I just introduce myself, my name is Kate Roberts and I work at a charity called Flex, or Focus on Labour Exploitation. And Flex is a research and policy organisation. We are an anti-trafficking organisation. We work to prevent trafficking for labour exploitation by looking at risks of exploitation in the mainstream economy and making recommendations around preventing those risks. My personal background is very much from a migrant workers' rights perspective, and as Neil said at the end, you know, there's so much focus from funders and others around modern slavery, often from an advocacy aspect. I will talk briefly about how the rhetoric has changed in modern slavery, but also from an advocacy perspective, it has previously often been more effective to do advocacy by highlighting risks of exploitation rather than promoting decent work. But I will focus on that in more detail. If I just try and move on, I won't cover the continuum of exploitation because I believe everyone, even if they weren't at the beginning of today, is now very, very familiar with the concept of the continuum. But Flex's focus, as I've said, is very much on preventing exploitation. And we've done and identifying exploitation, and we've done less work actually around articulating the concept of decent work. As others have said today, whereas we can recognise that exploitation exists on a continuum, if structures which allow for exploitation flourish, and there's an approach focuses very much on a modern slavery or criminalisation approach. This does leave, and what I'll talk about today is that the gaps it leaves in practice for people to address exploitation early on, and it leaves gaps where people don't actually have any options in practice to access their rights. And not only is this ethically wrong for those individuals, there's already been discussion today around criminal exploitation as well as exploitation which doesn't meet a criminal threshold but is nonetheless not legal and is not permitted within employment law. But obviously if people are not left with options which work for them in practice, as well as being terrible for those individuals and ultimately creating two tiers of workforce where some workers can be completely exploited in practice, it will actually increase exploitation at the sharper end as well. And I think this leads to two outcomes, and we're seeing these in the UK at the moment. As I mentioned, the UK has really, since the early 2000s, had a very strong focus on modern slavery, exceptionalizing modern slavery, having a criminal justice approach of the Modern Slavery Act 2015, and far less overt concern for protecting migrant workers' rights. Now, what do we really expect people to do in practice? And I think I'll give some case studies about this when they are in exploitation, but it doesn't meet the threshold of modern slavery. I think there's some seriously ethical and practical issues around this. The other thing I'll touch on very briefly is then we see we're beginning in the UK now to really see the vilifying of victims of modern slavery as well. You know, there's been a lot of rhetoric from the Home Secretary about people gaming the system. The UN experts, the special rapporteurs, recently wrote in December, you know, really saying this language where there's not even any evidence is really very dangerous, and you know we'll end up having real implications for people who will feel very unsure about coming forward with this sort of vilifying that anyone who says they might be trafficked is actually gaming the system. And I think we're seeing this with this exceptionalized approach, a focus on modern slavery, and then with more people accessing the NRM because they haven't been able to address their exploitation early on and move into decent work. Anyway, I'll talk about this in more detail. But in terms of preventing exploitation, you know, the UK hasn't really taken a preventative approach previously. And I wanted to give briefly two examples of where people haven't been able to access options or address or access rights in practice, really because of the immigration rules and how these have intersected with access to employment law. One example, which many people may be familiar with, is the overseas domestic worker visa. And this visa was actually recognised by the ILO as an example of best practice when it was created in 1998. It was actually included in the immigration rules in 2002, formally introduced in the immigration rules in 2002. Prior to this, domestic workers would come into the UK very informally, and issues really arose when they escaped exploitative employment conditions or exploitation because they had no formal status in the UK. The overseas domestic worker visa recognised workers as workers, and it did restrict them to a full-time job as a domestic worker in a private household, but it allowed them to change employer and apply to renew their visa on the basis of full-time employment as a domestic worker in a private household. So it gave people options, very limited options, but some options in practice to exercise rights because they could leave, they could find another job. What happened in 2012 is many of these rights were removed and domestic workers became tied to their employer. The visa was limited to 6 months, they couldn't change employer. And campaigning around that, because obviously at this time the UK was building up to its Modern Slavery Act. There was a lot of talk in the Modern Slavery Bill about domestic workers, and the build-up, the rhetoric at this time was really about, you know, what about these workers? You're actually creating conditions of slavery. And the general response was, well, if they're trafficked, they can enter the NRM. But of course, this is a very, very odd approach because, as you can see from the report, this is a Calian report from 2013, and reports by workers to Calian showed that the act of tying really increased the reported exploitation by workers. And really for those workers to be told, well, you can wait until your exploitation reaches the threshold of trafficking and then enter the NRM, really doesn't offer these workers with any practical solutions, given that these are migrants who migrated to support their families, you know, made a really difficult decision to support their families. There have since, I've got very limited time here, but there have been some concessions. In 2016, domestic workers were allowed to change employers, but only within the 6 months. So again, very difficult in practice. Domestic workers who do enter the NRM can have their visa extended. But again, there's a lot of issues of domestic workers thinking, well, I mean, many do not know the rules anyway. Do they wait to meet the threshold? It's not a very tenable solution for domestic workers who are experiencing certainly lower levels of exploitation. So wouldn't meet the threshold of trafficking, but are being exploited under UK employment law. I also I'm very mindful of time, but just very quickly, the agricultural seasonal worker visa is another example where the structure of the immigration rules makes it very, very difficult to access rights. This is an article around debts workers often incur to come to the UK on the seasonal worker visa, where we don't, it's a visa that is, again, 6 months. Workers have no recourse to public funds. They need to work only in the agricultural sector. They can change jobs, but only under the same scheme operator. And we don't have international standards around recruitment in place in the UK. So workers pay their own costs. Recruitment fees are illegal, but as we saw from the Guardian article I just had up, many workers do pay recruitment fees in practice, and it's very unclear what redress there is for them. You know, the GLAA licensed the scheme, but as Frank, I'm sure will tell you, they have no due restriction outside of the UK. You know, who is responsible if people have paid these high fees? This means that workers entering the UK are in a situation where they've got huge amounts of debt and pressure to earn enough to repay these costs. Are they really going to challenge poor conditions? What realistic options are there for them to challenge abuse? They may not meet the threshold for a referral into the NRM, but even if they did, would it actually be something that is of interest to them, given the need to work and repay the debts that brought them to the UK? They're not going to get to an employment tribunal and have redress within a 6-month visa, especially when they have no recourse to public funds, so will effectively become destitute if they, you know, leave the employment they're in. And of course, a UK employment tribunal wouldn't address the recruitment fee issue. So very, very briefly, where I'm probably out of time, I just wanted to very briefly mention the UK context and the current narrowing access to identification and support, even for people who do meet the thresholds of slavery. I mentioned very briefly the rhetoric around people gaming the system. Here is the part of the UN experts' condemnation of this, and actually the Independent Chief Inspector for Borders and Immigration's inspection report into adults at risk in immigration detention, just published earlier this week, last week, also mentioned how concerns about abuse have, and they use the word infected, the Home Office's response when safeguarding people in detention. There's a you know, a general rhetoric that people are gaming the system, that they're cheating the system, and they're not really victims. So even for people who do meet the threshold, it's becoming now very, very hard to access redress. You know, this comes off the back of the new plan for immigration and the real muddling of anti-slavery regulations with immigration, really in an attempt to justify an increased immigration enforcement response, which of course then further drives people underground and actually discourages people from coming forward or seeing the system in working in their interest in any way whatsoever.
Thank you so much, Kate. Some really difficult and pressing issues raised there, which hopefully we'll receive some questions on during question time. But before that, we have a few more speakers. So now I'll pass the floor to Ake.
Thank you. So my name is Ake, so I'm the founding chief executive of Modern Right Network. I used to work for the trade media the trade media to set up Migrant Awards, an organization led by Migrant Experience. So the way we work, so we provide support to only migrant on the ground. So sometimes it's really, really difficult to get migrants to challenge employers or to report all these labor right abuses in the workplace. So what I do all the time is to go undercover. So I am French citizen, but I'm also Ivorian. So I have 2 passports. So the French one and the Ivorian one. So what I do, when I hear from the community that some employer are behaving badly, then I apply to work with this particular company. So first, I do it with my Ivorian passport, which is a passport I had, the very first Ivorian passport I had when I was born, so it's expired a long time ago. And when I came to the UK in 1996, I had a visa in there. My visa is expired. So which means based on my Ivorian passport, technically, I will be disqualified from working in this country. So sometimes I go into these workplaces to apply for work, and many employers recruit me, even though technically I don't have a legal right to work. Then when I go undercover, then I realize what is going on, and I see a lot of people confused who do not want to report these problems. So the other strand is to go undercover with my French passport. As you know, we're no longer in the EU, so I have, I'm settled in this country, so I have my settled status. So I go undercover with that. And it's really, really challenging to get work because of many employers do not understand how the right to work check work. So I did undercover work with Uber as a delivery driver. So you are self-employed. So technically, the right to work check does not apply to self-employed people. But what Uber then does is they make you go through a series of checks. So first you provide all the information to them. And then after that, they outsource this to a second company called Sterling. So Sterling carry out the right to work check on the behalf, which is wrong because when they do that, the employer does not establish statutory excuse. So once Sterling has done that, then they outsource this to the post office. So you go to the post office. Now the post office check your document and you have to pay the fee. It's not a lot, but you're not required to pay any fee, but you still have to pay the fee in order for you to work. So these are the kind of processes a lot of us migrants have to go through. So when we talk about decent work, it's about opportunity for people to work. So the work we do on migrant work, we only focus on migrants who have the legal right to work in the UK, so therefore should be able to work. But when you have to go this system where the employer has to check your right to work, but they don't understand that you have a legal right to work. So which means you have the right to work, but you cannot work. So how do you provide for your family? Then that's where a lot of people work cash in hand or fall into this in exploitation because they have to work to provide for their family, even though they have a legal right to work. So these kind of issues are not being picked up by the trade union. Because the trade union focus mainly on employment issues, not on immigration issues. So when you have these kind of issues, so you sit at an intersection between immigration law and employment law, you cannot find any support because trade union cannot provide this kind of support. So that's why in the community, I've been pushing a lot of our people from our community to turn to statutory agencies because like the JLAA, and we have reported this to the JLAA because the JLAA understand the issue and they can tackle these issues. So that's how the system created to tackle labor exploitation actually create labor exploitation. And we have moved away from the term modern slavery to homegrown slavery because these are not migrants who have been recruited from overseas, brought to the UK to work. So these are individuals like myself who live in the UK. I've been living in the UK for 60 years. So we live in the UK, we have a legal right to work, but the system created by the states push us into labor exploitation. So that's the first one. So now we also have a number, after the right to work check, we have a number, the identity document verification technology check. It's another one. So the employer is required to check that your document you have is a real document, you have the legal right to work, but these only apply to British citizens or Irish citizens. But because the law is complex, employer will carry out the right to work check on everyone. So it doesn't matter whether you have the EU passport or British passport or Irish passport, they will check everyone. So when they check that, this creates another problem, because if you take the case of asylum seekers, for example, who have permission to work, these asylum seekers, when they've been granted permission to work on the shortage list of occupation, they have the legal right to work, but they do not have the identification document that employers can use to check. So these individuals have the legal right to work, again, cannot work because they don't have the proper document. So therefore, they don't have the opportunity to work. We know that a lot of employers are pushing for migrant, for the Home Office to open a new labor migration route for employers to recruit. But you already have people who have the legal right to work in the UK, but cannot work because the system is too complex for the employer to understand. So many people in the migrant community are denied the opportunity to work. So now those who are in work already go through these kind of issues. I'll give you an example. There was a lady who was on a work visa. She was working for this employer for over 10 years. And then there was a to be transfer. So the employer refused to allow her to transfer to a new employer because her visa was expired. You said it's expired, so therefore she doesn't have the legal right to work. But before her visa expired, she renewed it. So technically, there is what we call Section 3C leave, which extends your leave and your right to work until the Home Office processes your application. But because the employer did not understand the law, the employer refused to employ her. So she took the employer to court. She won her case. But the problem is that everyone was already transferred to the new employer, and there was no job for her anymore with the new employer. So the Home Office heard her case, and the Home Office accepted that it was not her fault. So instead of revoking her visa, they agreed that if she's find a new employer, she can carry on working. She has looked for a new employer for a very long time. She could not find a new employer. So in the meantime, she was working because she needed to feed herself. But the Home Office heard that she was working in another job, which was not qualified to work. So therefore, she technically, even though she had the legal right to work, she was working in a different occupation. So therefore, she broke her immigration condition and her visa was revoked. And at the beginning, when she told the employer to go, the employer argument was that she was working illegally. But if you have the legal right to work, how can you be working illegally? So that's what we see a lot in the community, is that employer will employ somebody who has the legal right to work, and for many different immigration restraints. And when that individual visa expired, or there is abuses in that workplace, the employer will ensure that that person's visa is expired. And when that person's visa is expired, we have many cases where the employer is in charge of renewing that person's visa, but the employer does not actually renew the visa. So when that person's visa is expired and the individual want to take the employer to court, then what the employer does is to fund the Home Office, saying that that person is working illegally. So therefore, the Home Office, that person is liable for deportation. So we have here a system that creates vulnerability. The individual immigration study itself is not what creates vulnerability. It's the system built around that individual or around migrants for different immigration strength that create this level of vulnerability.
Some really powerful points there. Really very, very interesting. Thank you. Should we hear from Frank now?
Well, good afternoon, everyone. I'm Frank Hansen, Head of Prevention Partnerships at the Gang Masters and Labour Abuse Authority. A lot's been said, and there's a lot of ground to cover, what I do want to focus on is this, this theme of decent work and that spectrum around modern slavery. I think with the GLEA, we've got three primary functions. So we are a regulator. So we regulate the supply of workers coming into the fresh food sector, so agriculture, horticulture, and all the associated food packaging processing with that. We're also an enforcement body, so we've got powers both to enforce on criminal and civil enforcement. And we're also, key function is prevention. So I suppose we move around in that spectrum all the time, depending on our function, which makes it really difficult to, I suppose, give where our position actually is, because I think those functions dictate to a large degree where we operate in. But what I will do is I'll speak from a prevention point of view, because we're doing a lot of work around education, around raising awareness. And we realise that the subject of worker rights isn't really covered in the education curriculum. There's a lot around employability, there's a lot about safeguarding, there's areas around citizenship, but actually we didn't feel there was something that really reflected what it's like to enter the job market either as a young person or as an adult, and looking at the way the economy is now shaped, and looking at things like the gig economy, looking at things like the practicalities of searching for a job, particularly the threat from online fraud and deception when people are searching for jobs. Things like reading the payslip. How many people actually know how to read your own payslip? And we found a lot of people, when they were having deductions, they just simply didn't know deductions were being made, because their payslips, if they got one, even when they got a payslip, it was so complicated to understand deductions. So this has been a really long journey, actually. We started about four years ago. We piloted the idea of introducing it with a college in Boston, in Lincolnshire. And from that, we've now got to the stage where we designed this level 1 award, and it's a very short course. It can be done online, it can be done classroom based, but it is a qualification. So it went through all the rigor of getting a qualification through Opqual. We piloted it in quite a diverse range of settings, because we know it's not just about a college setting. We wanted a workplace setting. We piloted it within a centre that works with those going through recovery from addiction, because we know there's a vulnerability people have with addictions. We piloted it in a secure young offenders institute. Anywhere where we felt that kind of need to find out about your rights, about how to search for a job and to stay safe, and then also what to do when you did encounter a problem. My biggest concern, being with a GLEA with such a small organisation, is we didn't want everybody ringing the GLEA up, telling us that they haven't had a lunch break. What are you going to do about it? So, and I would generally, we were frightened that we would create this fear that you have a problem, then straight away it almost goes from zero to modern slavery. So we tried to design it in a way that people could help manage the situation depending on the level of issue that it was. And actually, the first thing you do is obviously talk to your employer, talk to your supervisor. But if you can't do that, then using those different tools, and we know how fragmented it is trying to find solutions to workplace issues. But we did try, and as I say, to make it proportionate. So agencies such as ACAS, such as Citizens Advice Bureau, local advocacy groups, and then when it did become, or if it was becoming more serious or more threatening, then agencies like ourselves, Health and Safety, the Modern Slavery Helpline. So we went through a whole process. We had fantastic support from the University of Nottingham Rights Lab, who helped us with the evaluation. We created it in partnership with an agency called the Skills in Education Group, who are an awarding body who I've been involved in education and workplace-based training, and it got launched nationally last year across England and Wales. And again, it's been promoted and delivered in different settings. We've done a lot of work in Leicester because on the back of allegations of modern slavery in the garment industry, there was the GLA led an enforcement campaign, if you like, working with other agencies. But what I was doing was much more about how can we build links with local communities? How can we develop awareness within local communities about not just giving them awareness of their employment rights? Because I think what we're finding is, yes, you can give the education, you can give the awareness, but are you giving people the confidence to articulate their rights? Are you giving people the confidence to enforce their rights? And that is a much more challenging, I think, area for us, because for a lot of people, those vulnerabilities that Aki's mentioned and it's been mentioned by other speakers, whether it's their immigration status, where it's just precarious lives that people are leading. You know, employment may be just one issue. They've got having to manage, it might be housing needs, it might be benefits advice, a whole range of other issues, and employment is just one that they've got to juggle. So we've been really grateful with agencies such as the Sharma Centre in Leicester, who are a charity that have been around for, I think, over 35 years, working with predominantly BME women in Leicester, because they're understanding, I suppose, how people need that safe space, they need that confidence, they need that support to be able to manage what are big challenges in their lives. So we've done a lot of work with the Sharma Centre in understanding how can we adapt this qualification, how can we adapt this learning to meet those different needs. And using that learning, we're working now, and it's just literally the beginning, but we've got a project working with the Romanian embassy, where we're actually going to design an abridged version of the qualification. So it's no longer a qualification, it becomes, you know, a course, basically a 3-hour course, but takes the key elements, and we're going to train the trainer. So we want to work with charities, NGOs who are serving the local Romanian community, and actually use them on a professional service. This is not about them doing favours, this is about having a proper working relationship. So we want to commission so we can train them to deliver this 3-hour course. But in doing so, they start to tell us about, it's not just the language barrier, and we're going to have it translated in both Romanian and English. It's also about terminology. It's all about using words that we use quite freely, that for a lot of Romanian workers, they won't recognise, or they'll understand it in a different way. And we want them to give us that kind of insight. So when we do complete the design, it's hopefully going to be as accessible and as engaging as a course, to give them, as I say, not just the awareness and the skills, but the confidence that the majority of Romanians in this country have a legal right to work. They've got a good reputation for work ethic. They've got a skill set that is in demand. They should be aspiring to good, decent work. A lot of the barriers we face, a lot of the jobs they've taken may have come through contacts with family and friends. And there's almost an obligation to stay in those jobs. And what we want to do with the support is actually encourage and get them to recognise that they've got a real, I suppose, asset, that they should be confident that they can secure good, decent work that reflects and pays them their worth, their experience, their skills, and move away from this, I suppose, this vulnerability. Yes, there is a vulnerability there, but actually it can be overcome, and to see it now as a strength that they've got in a UK economy that's desperate for skilled labour.
Thank you, Frank. Yeah, this level 1 qualification sounds like a really good start in building those foundations for worker empowerment. So thank you. And last but certainly not least, we have Peter.
Right, my name's Peter McAllister, Executive Director of Ethical Trade Initiative. There's a lot that's been covered already, so I'm not going to repeat it. I might highlight a few things because I think we're in furious agreement on a number of things. We're a tripartite organisation. We bring together companies, NGOs and trade unions. That gives us an insight into some of the labour rights issues, not just in the UK, but globally. And our sweet spot is by getting those different parties to work together on promoting labour rights. That's framed in the form of what's called the ETI Base Code, which is essentially the ILO Core Convention for Dummies. It is a very, very simple version of things, but the idea is it can then be applied globally. And the way we talk about that now is much more in terms of human rights at work, so in the context of work looking at the broader human rights. Since 2011, we've adopted UN Guiding Principles as a framework. Something's not been really talked about actually in the last few speakers, partly because that is a universal tool, partly because we think it's a very strong and credible tool. If you know the UN GPs, Pillar 1 is about the role of the state to protect workers. We've heard a little bit about the failure of that in this context, and in many contexts we work, the state is not just failing, in some cases the perpetrator of violence. You look at Myanmar, for example. So making sure that the state's playing its role is really important. However, the second pillar is about businesses' responsibility to respect human rights. And if you look at UN Guiding Principles, it's not framed as a passive compliance. It's framed as an active role for business to find out what are the salient risks in their supply chains, what are they doing to mitigate those. And that's quite a change from a typical sort of ESG social compliance approach. I wouldn't say everybody's got that, but that's the way that's from. Then lastly, it's about remediation, both in terms of the state's role in remediation, but also then private approaches to remediation. Well, I'll be the first to tell you, I can guarantee you that in supply chains of the company members of ETI, there will be modern slavery. Okay, and for government departments to say there isn't just shows me, frankly, how ignorant they are of their supply chains. It is real, it is happening, as well as other forms of exploitation. ETI makes no guarantees. We're not a place where you can come and get a t-shirt or a badge. It's because these things are real and dynamic. It's an approach to try and have a continuous improvement. We learn from our members all the time. We're challenging them. We're working with Kate on the source scheme, which is incredibly poorly designed in my humble opinion. So it is about recognizing these things exist in real time. They exist everywhere. And the effort is to try and expose them and work on them. And I think the point made earlier on is it's very difficult for a company to stand up and say, hey, look, we may have reduced slavery this year. This is not the sort of thing the public wants to hear. And it's not the sort of thing the board wants to hear, but it is the reality. You've heard the continuum. I won't go over that, but I will say it works both ways. So you've got a long continuum in terms of decent work and decent conditions and pressures in, if you like, the rough and tumble of seasonal work and so forth, right through to very egregious modern slavery. But more often than not, they don't exist in isolation. So some of the indicators we see, if you see regular and systemic abuse, you would ask yourself what else might be going on in that context, or in the suppliers, or in the agents that work in that context. So these things are not disconnected, and it's useful to look back and along that continuum, if you like, both ways. Unfortunately, much of the modern slavery we see is intentional. It is not accidental, it is not a failure of process, it's not bad HR, it is intentional. Groups set out to exploit other people. Typically, those people are vulnerable. They may be migrants. It could be within an internal migration with India, for example. It could be across the border, but it's not only migrants. It can also be vulnerable groups within the country. And that defines a little bit modern slavery. Is this isn't poor practice. This is intentional. People therefore will hide it. They change the approach to modern slavery. GLA has done some great work on looking at the ways these things change over time in different industries, different sectors, different practices. So it's a dynamic thing that requires very much active engagement. Looking at the UK context, we probably also talk about the European context, the pressures that are on supply chains at the moment, the pressure on prices, the consumer pressures, inflation, cost of material, will drive price pressure down the supply chain. At some point, somebody's willing to cut the corner. Somebody's willing to provide labour below cost. And of course, that translates very quickly into exploitative practices. So it's also welded into the way the economy comes and ebbs and flows, and the power dynamics along that chains. Social auditing, it's a tool in a box, but it largely fails to tackle modern slavery. So yes, it's a tool if you If you imagine it's like a sort of GP 15-minute check-in, if you're ostensibly healthy, that's useful. If you've got a chronic disease, it's not much use at all. You need to go and see experts. So it's about widening that toolbox to say, when was the last time we took a deep dive? When was the last time we did an analysis? What does our questionnaire tell us from government, if you like, that approach? But then when did we take a harder look at sectors or practices that are warning flags for those of us who work in this sector? On the decent work and modern slavery, that was really interesting. One of the things listening to the previous panel, because clearly as ETR, we're committed to the decent work agenda. That's part of embracing those larger aspirational forms of work. And I would say that one of the things that decent work brings that modern slavery as a concept doesn't is this role of representation agency of workers, specifically trade unions, acknowledging their limitation. But where you have trade unions active in a workplace, in industrial relations, dialogue with the employer, there are good checks and balances in place which help not only identify exploitation or issues, but also deal with grievances before they become legal. So we would argue that where trade union representation is strong, that's one of the bulwarks, but it doesn't cover everything. And I think you've also pointed to some of its limitations. However, I would worry if we soften all the language down to something like decent work, because there is no doubt that when Modern Slavery Act was passed in 2015, that made boards sit up and take note. The amount of activity we saw, the amount of lawyers who got some money through trading schemes and what have you to try and educate boards. What is this modern slavery thing? How do we comply and what should we do? It has that hardness and focus about it, but it does sit on a wider canvas of decent work. So smarter minds than me will have to help us. How do we make sure we don't lose the sharpness and the focus that modern slavery brings to this debate, but recognise, as a number of people said, that it's associated with more aspirational issues that we want to see in terms of moving along the sort of decent work agenda. Well, so we talked about some union guiding principles. Yeah, that's not been really talked about as much as maybe I thought it might do, because of the requirement within union guiding principles for business to demonstrate human rights due diligence. Not a gobbledygook. What does it mean? What it means is demonstrate what you're doing to identify where those risks might be. What steps are you taking as a business or with your business partners to mitigate those risks? So if you ask Tesco's, and I'm not speaking out of school because they've talked about this publicly, when the issues of slavery in the fishing boats off the coast of Thailand came up, they analysed it was about 8 steps down their supply chain. Why did they engage? Because the practices were so egregious. This was brutality, this was people being thrown overboard, this was the worst types of modern slavery you can imagine, but they did want to be associated. So it's not about first tier, and it's not about where you want to look, it's actually about where these practices might exist. And then very quickly, who do you need to work with to try and get leverage and engagement? And all this is within UN guiding principles. So it should move companies from we haven't seen anything, therefore there can't be a problem, to this is what we've done to try and assess risk. This is who we're working with to better understand that part of the world. This is who we're collaborating with to get leverage over these sorts of conditions. It's all there in UN GPs. It doesn't need to be reinvented, but it is a mind shift for most companies away from a compliance approach. So it's not a magic bullet for modern slavery either, but we think that approach is probably underdeveloped in terms of putting the onus on companies, not to demonstrate you've got policies, but what did you do in applying those policies in the last year? What did you find? Who did you work with? And how did you respond to those? Going back to the first pillar, there is no doubt about it that where you have effective policies and procedures, where you have well-financed organisations and agencies, it is easier for business to work within that context. But at the risk of getting beyond myself a little bit, I think what we've seen over probably 20 or 30 years in this sort of liberalisation is those agencies and checks and balances have largely been underfunded, not just in the UK, but globally. And therefore we're relying much more on civil society and NGOs to step into that space where largely it's a failure of governance to provide the public good of following through on the laws that exist, making sure agencies can do their work, and in the worst case, making sure the agencies aren't covering up because they're getting incentives, the very things that we're trying to tackle. So that discussion around the making sure business isn't being held accountable for a failure of governance is something I'd be really interested to hear other thoughts and opinions on. Not to let them off the hook, by the way, but to recognise that they cannot replace the governance and they have a job to do. of their own. So last and not least, and again, this was picked up by others, if we're not serious about this as a society, if we're not prepared to hold businesses to account, if we're not prepared to make example of these things, then we're joking. Because it cannot be solved with all the good efforts of the people who's sitting here. We cannot solve these things if the wrongdoers are not held to account. On corruption, if you look at the anti-corruption laws, we do it. So is corruption more important than slavery? Because we are not in this country providing the same sort of checks and balances and following through on companies associated with the same force that we are in corruption. That's a societal choice. And frankly, at the moment, the rhetoric is we don't want to burden business. What I can tell you from most of the businesses I work with who are in the public eye, they're on the high street, they work very hard, but they need a level playing field. They need government to meet them halfway. And again, I think GLA does a fantastic job, but it's only one agency that is under-resourced to try and fill that gap. So there really is a need to get this collaboration between what the government should be doing and taking responsibility for, holding the people who get this role to account, working with business as we do because they have a role, and then working with civil society that fills in some of the gaps, the research. It is about getting that collaboration working well, but that requires the sort of dialogue and the leadership that we need at a national level. I'll stop there. I hope I haven't abused my time.
No, it's not. Thank you so much. That was a really great conclusion to our speakers' comments. Now, I will open up questions. Should we start with the online questions maybe this time? Okay, just have a look. Okay, so we have two from Josh Goldbugler. So he asks, what do you think are the most impactful interventions world governments can take in support of workers' rights? And he also wants to highlight that the Welsh government has published its Fair Work Guide. I'm not quite sure who this question is directed to, but would anyone particularly like to start off the discussion?
I'll have to go with a very simple answer: prosecution, because nothing gets through to the business environment in this world than if they know they're going to be held to account. You look at the Modern Slavery Act, we still don't have everybody who should be covered by the act reporting. We don't have any examples of when that's prosecution or practice. So government needs to walk the talk and hold people accountable in the public domain for not meeting their obligations. It's not the entire answer, but I can guarantee that would make people sit up and take note and ask, what are we doing? How do we make sure we're not caught in that situation?
Would anyone else like to jump in?
Yeah, I will say a brief thing. So the first one is that government needs to listen on board to people, organizations like mine, and many of us will have lived experience. And these organizations, the second thing, these organizations need to work more with statutory agencies like the GLA. And thirdly, the trade union need to open up and work with community organizations, which can happen.
Yes, there really needs to be this multi-layered kind of approach. Okay, Neil.
Yeah, hi. I'm sorry it's so dark in my office at this time of day. It gets really dark here, which isn't great for Zoom calls. Two things. Firstly, public procurement. You know, public procurement offers the opportunity, it gives the opportunity for governments to set a high bar of the standards that they expect. So firstly, look at how the public purchasing in any given country is being undertaken, what due diligence is being undertaken on that, but also importantly to build the capacity of government staff to undertake that due diligence and to be looking where the government pounds are being spent. We did a project quite some years ago now looking at public procurement, and to be honest, we were rather aghast at the lack of knowledge and capacity in some of the government procurement departments who were responsible for quite large budgets of taxpayers' money. So I think it is, and it's moving away from this idea of government having a kind of bolt-on CSR or sustainability department, this is what companies themselves have found, and making this much more of an integrated part of the way that public procurement is undertaken. And also it gives governments the opportunity through public procurement of rewarding companies who put in the effort, and an expectation of companies that they can demonstrate the things that we would like to see. To give you an example of that, the GLAA operate a construction protocol. So companies can sign up to the construction protocol. They have regular briefings and meetings around the things that they should be looking out for within that particular industry sector. Well, I could see nothing wrong, and would see it as a positive good, that public procurement in England, in Wales, in Scotland could also all make sure that they do not provide contracts. It's an expectation of tendering that you are a member of the GLAA construction protocol if you are going to be bidding for public contracts. And that's just one example of the sort of things I think that governments could do. I think that governments could also support and back business initiatives as well. You know, there's things like the Scotland Against Modern Slavery. There are various trade associations and initiatives in place. Government support for those things is significant and would increase their membership. I'm quite certain those collective voices can be really significant in pushing whole sectors towards better practice. It's not a magic bullet, but it does help us move towards where we would like to be. There's also the other things that governments could do would be things like producing toolkits to advise companies about where they should be looking, where things that they could do to check through with their supply chains, those sort of things. For smaller governments, a good examples, I think, can be found through an organisation called HUNI. I'll put a link in the chat shortly. They're an organisation made up of mostly Scandinavian governments connected to the United Nations, and they've produced a range of tools for businesses operating in those regions to help work their way through some of the due diligence challenges that the government would expect from them. So there's things that governments can do within their own procurement, and there's ways that governments can support businesses operating within their jurisdictions.
Thanks, Neil. Frank, did you want to add anything to Neil's comments about the GLAA?
No, other than I think it's important that government does work well with business, and I think there's still a need really for the relationship with SMEs in particular. I think SMEs are the backbone of the UK economy. They see more, they hear more, they're often rooted in communities, but I think sometimes they haven't got the capacity, they haven't got sometimes the time to really grasp this and this subject. I think there's more needed really to build that relationship with SMEs, and through things like the Chamber of Commerce and other bodies that represent them, because I do see they're a really untapped source of, as I say, knowledge and experience. And I think there's some research actually that was done in the West Midlands with some of the universities who were starting to look at how can we bring SMEs in particular who have got this crying out for labour, where we've got people who have got the legal right to work, but bringing them together is so difficult, as exactly explained. The lack of confidence or the lack of awareness of employers to employ those who've got a right to work. Who often have got the right skill set, have got the right qualifications, and I just think that's for me it's a win-win for employers. It's a win for those who've got that right to work, because if they don't go into that decent work, that's, as I explained, the vulnerability. Then they get drawn into the grey area, the work where that exploitation can occur.